rape and domestic abuse. Isn't it? And in 2001, when I was first elected as an MP, I was asked by Fawcett to chair a commission on women and criminal justice. It was to cover women as victims, women as defendants, and women as workers in the criminal justice system. So we put out a bid for evidence from victims, and we got back stacks about rape and domestic abuse. Having got that, we thought, well, okay, but women are victims of other kinds of crime. We'll put out another bid for women as victims about things like burglary and antisocial behavior and how they are dealing with being victims of that. And we got nothing, absolutely nothing. What bothers women are offences specifically against women as women they care about and of which they are afraid. And I would add to domestic abuse and rape harassment and being afraid on the street. And I fear that these offences are the crimes that are dealt with most weakly, worst by our justice system. And I'm going to venture 3 reasons why it might be so quickly and then tell you where we are. So firstly, the whole criminal justice system has been undermined by cuts. They have resonated in an amazing number of ways, but in particular, point 2, by a lack of specialist understanding in the police and the CPS and in the courts, which has been sacrificed during austerity, because cuts don't they, undermine first and foremost the more complex and sensitive, harder things to do. And these crimes, domestic abuse, sexual offences, are sensitive. Victims are traumatized. They need to be dealt with in a trauma-informed way. Coercive control, a very complex concept. A course of conduct in domestic abuse, much harder to investigate than a burglary, isn't it? Thirdly, I think lack of availability of support from organisations like Women's Aid and Rape Crisis in the investigative process, because there are simply too few of them because they're not funded. I would like to mention misogyny, but that would take me a lot longer than 40 minutes. So let's just leave that one be. Let me, before moving on, make 2 more points. Firstly, very, very few rape or domestic abuse victims ever engage with the criminal justice, ever go near it. 80% do not. They just want help. They don't see the courts as a solution. Consequently, Rape Crisis have 14,000 women on their waiting list for counselling. The Domestic Abuse Commissioner tells me that fewer than half of women get the specialist domestic abuse support that they want. So we're not doing a lot for people who need help but don't look at the criminal justice system anyway. But let us now look at the criminal justice system, because though it deals with small numbers of these cases, it is a lot of the criminal justice system. Domestic abuse alone is 30% of all police recorded violent crime. And domestic abuse alone is 18% of all crime reported to the police, all crime. And that's 846,000 cases of domestic abuse. And on top of that, there are 70-odd thousand complaints to police of rape. Those complaints are increasing all the time. That doesn't mean necessarily more domestic abuse, but more going to the police. But the cuts again. We now have recruited, I think, 13,000 what this government calls new police, but of course we lost more than 20,000 police during austerity, which is just government cuts. When I was the Police and Crime Commissioner in Northumbria, I had supervised those cuts. The most expensive police had to go, the ones with experience, the supervisors, the specialists in public protection units which deal with these kinds of crimes and child sexual exploitation, detectives, of whom there is still a big national shortage. And then it turned around and they were replaced in a hurry, because now we have to recruit police with inexperienced generalists who fine want to join the police. But these issues are, as I've said, very sensitive, quite a few police forces have abolished their specialist units now, and these cases are dealt with by raw generalists, and with cuts, the most difficult and the most complex cases are the first to go. Let me give you an example. I think anybody who's been involved in domestic abuse had high hopes of a new offence introduced by Theresa May of coercive and controlling behaviour. This criminalises repeat or continuous controlling behaviour towards somebody, and it has a serious effect on them, which the perpetrator knows perfectly well. So in real life terms, it's about non-stop belittling, starving your partner of money, blocking their friendships, not letting their mother come, refusing to let them go out except to get the kids and to do the shopping for that partner's needs, threats of violence, daily threats. This is the lot of many, many, many domestic abuse victims. It is all to overpower the will of the victim so that the perpetrator is in charge. Unless that's understood, even if the police come when some emergency case occurs and they attend, they will just see unconnected individual occurrences, and they'll even get a bit weary if they're called out 2 or 3 times to the same house, because it just looks like repetition. So this understanding that it is a syndrome, really, that when she calls you in, she's not free all the same. She was just panicking because it was so awful, but she is not free because he's there, and if he's not far away. And you need to understand that this is part of what is going on. But there have been so few prosecutions taking up this proper way of looking at the harm in domestic abuse. I think there were 34,000 prosecutions out of that 846,000 complaints that I mentioned this last year, but it's worse than that. It's never charged on its own, it seems. It's charged with an assault, a black eye or something like that. And Women's Aid tell me that 86% of coercive and controlling behaviour, setting out the whole of that syndrome, which she wants help with as a whole, 80% of that kind of charging is dropped if a perpetrator pleads to violence, to a black eye or whatever it is. And Women's Aid tell me that there were a grand total of 374 convictions, 374, no thousands there, in 2021. This is from a new report called Come Together to End Domestic Abuse. So the worry is that that conceptual shift Theresa May intended hasn't happened. And black eyes are seen as the wrong. And of course, they're seen as minor. And it's all done in the magistrates' court. We'll come to the magistrates' court presently, but the whole issue is not being grasped. So we had high hopes. It didn't work. Leave, for the moment, coercive control behind, not been a great success. We have hopes for it soon, but some more sobering data. Remember, the gatekeepers to the CJS are not the police so much as the Crown Prosecution Service. And though domestic abuse crimes recorded by the police are high, prosecutions have slumped for the past 5 years. My ex-colleague, the Domestic Abuse Commissioner, that's to say I'm the ex, says that comparing 2016 and now, charges are 48% fewer and convictions are 46% down for all kinds of domestic abuse, including the black eye. And what the inspectors of police report is that 3/4 of all domestic abuse related crimes, remember the charges have collapsed in the way that Nicole, the Domestic Abuse Commissioner, describes, 3/4 of those are dropped. And they are dropped because complainants feel that they're unable to go on and support the prosecution. They are not given the support they need. The queues are very, very long. This is the same kind of trajectory as the far more often discussed decline in rape prosecutions. Those fell from 3,800 and odd in 2016 to 1,750 in 2019. They collapsed by half in 2 years. And they have only, despite the pressure, despite the noise, despite the complaints, come back only to 2,230 this year after 3 years. The Crown Prosecution Service is a whole story of its own. It's also had cuts, but there are cases the police want to take that the CPS will not take. You may even have seen today 3 senior chief constables asking to have the power to make charges themselves again and not have to rely on the CPS. Let's just very briefly look at the courts. 2 to 3 years now for a rape case that gets through that collapse of prosecutions to get to court. Just think what you were doing 3 years ago and try to imagine all of the time from then, waking up every morning thinking next week might be the week when I have to talk about what that man did to me in all its intimate detail in a public place. Imagine living with that for 2 to 3 years. And again, there are massive dropouts, and those that don't drop out are almost tortured before they ever get to court by the length of that wait. It's pretty depressing, I'm afraid, but let me mention a couple of good things we can do. And let me mention one good thing that is beginning to help turn around, in particular, rape and sexual offences. There is a project invented almost literally by the female chief constable of Avon and Somerset Police, which is called Project Soteria. That's a Greek goddess of some kind. I don't know entirely who she is, but the inventor of it took it to a minister, and the minister said the only way we get any money for things while Boris Johnson is the prime minister, which he was at the time, is to give things a Greek name. So it's named after a Greek goddess. However, what it is that chief constable invited some senior academics into Avon and Somerset Police who were the bottom of the charging list completely for rape. Come in and tell us how to do it better, she said. And they looked at what they were doing. They did intrusive deep dives. They looked at case reviews, surveys, conversations, and they said, this is not a rape investigation unit. This is a victim credibility investigation unit. It's all about, shall we support this woman? Is she telling the truth? What's wrong with her? So that if we take it on, we might come a cropper. Officers were not even interviewing suspects. They didn't, for instance, know how many repeat offenders, were amongst the people who were being accused by rape complainants. Avon and Somerset have taken on a model to neutralize this. Of course, this kind of investigation of the complainant is not done in any other kind of case. Suppose same woman accuses same man of an assault in the police. They don't want everything about you. They don't say, we're investigating you first. They don't, for instance, want what I'm going to mention now as something that we might be able to launch a campaign about. If it's not a sexual assault, they don't want what they ask for in rape cases, which is your telephone, your mobile phone, to be downloaded almost completely to see if there's anything on it to your discredit. The records of your medical history from birth, your school notes from the day you started school to the day you left, even if you're 35 now. Over the last few years, when this kind of behavior has come to light, the Information Commissioner, the Crown Prosecution Service itself, lots of campaigners and the ex-victims commissioner have reported that the CPS and police have frequently been incredibly over-intrusive and the requirements for rape complainants' confidential material. This is, again, about just looking through to see what's there. Obviously, if somebody's had a relationship with the man, that they now say has raped them. They want to have what's on the mobile phone between them, and they want to know anything relevant, but it goes way, way beyond that. I was present at a case where the prosecution had found all of her school records, and they had read them all. And in cross-examination, a complainant then about 27 years of age had it put to her that she was a liar and always had been. The evidence that she always had been was a letter that the barrister read out in court, which showed that when she was about 12 or 13, she had written a letter to the school saying she couldn't go swimming that day because she wasn't well, and she had forged her mum's signature. That was, I mean, in itself, a worthless piece of information, utterly irrelevant. But imagine you're the person who's been waiting 2 or 3 years for this to come on, and you're suddenly hit flat in the face by something wholly irrelevant, completely to your discredit, and you wonder what on earth is coming next. And she crumbled completely. And it is not that, you know, it has much value, that the jury is going to take it hugely seriously, though I could make a good speech about that. It is the impact on her. And that's the level that it became to. It became practically routine for rape complainants to be asked to hand over all of this. And we have loads of data now that's about 65% of rape cases referred by the police to the CPS involve disproportionate and unnecessary requests. The end-to-end rape review, which was run by the government, included a research report which described the CPS saying how important it was for as much material of this kind as possible in all cases to be given to the prosecutors before they even decided whether to charge. Now, in all cases, that means in stranger rapes as well, when she's never met the person before, and it's hard to see how any personal data is likely to be relevant. We have campaigned enormously on this. 1 in 5 victims in a survey we did say that they had withdrawn their complaint of rape, at least in part, due to privacy concerns of exactly this kind. There was an increase in withdrawal of rape complaints pre-charge from about 20% in 2014-15 before any of this was requested to 42%. So withdrawals have doubled between 2014 and 2020. And the answers we got to our survey was that this was a major point. Last year, we persuaded the government to legislate to limit this kind of intervention. There is a strong, restricted framework in a bill that became an act last year, and we are very, very pleased indeed about that, for phone material. And the government intends to consider similar tight framework provision to limit the search of material like school and medical records. And I feel quite hopeful that it will be good and that women are no longer going to have to disclose all of this permanent material or just withdraw. But there is one real problem that is not going to be handled by this framework, and that is that victims of sexual assault likely to be traumatized and in lots of cases can benefit from counselling and therapy. Their future well-being might depend on good counselling and therapy, as may their willingness and confidence to give evidence at court. But many sexual assault victims hesitate to take therapy because of concerns that those notes of the therapy made by their counsellor will be requested on the same basis by the police and the prosecution, and may in the end be sent to the defendant if they're regarded as in any way relevant. Clearly, the last person somebody who's been raped wants to let know how it's affected them as the man they say raped them. And they do not dare risk it. And many, many people, again, just withdraw. I mean, they don't want the police and the CPS to access their notes because those agencies are not seen as friendly, but as hostile for making these requests. And demands for these therapeutic records are made much of the time, and cases are frequently dropped if they won't sign them over, and frequently people withdraw. and this is done, though there is a current legal precedent that I've argued endlessly that this material should not be sought unless it's part of a reasonable line of inquiry, and we think there's something in it that will undermine the prosecution or assist the defense. But the new law that they've enacted for phones, that will enact for other material like school reports, isn't tight enough to do what most people think should happen, which is just throw therapy notes totally away from the case and don't have access to them. There is rarely anything of importance. It would only be if somebody had told a fundamentally different story to the therapist than what they told the police. But therapy is about how you feel, not what the facts are. So it isn't about evidence. And I suppose just looking at the sort of skeptical scenario, maybe you're going to a therapist because it's all untrue and you've got to put up a good pretense that it's true. Pretty fanciful, because you've got to wait about a year to get to a therapist. If you haven't been raped, there seems to be absolutely no point in doing it. And if it's all part of a pretense that you have been raped and you're going to therapy, then you are not going to tell your therapist that it isn't true that you've been raped. So it's a wholly false point. But many victims of rape and sexual assault have been choosing between justice and their right to the help they need. Many think that their recovery is far more important. They'll drop the case to keep their privacy. That means they get no justice, and it means that the criminal is free to offend again. Most rapists, research says, are serial offenders. And on the rare occasion that an allegation ends up at trial, victims can be ambushed in this highly intimate way about what they said about how it happened. And of course, they're not my notes as the victim, they're somebody else's. I've never even had a chance to look at what they've said. The intrusion of the risk with therapy notes are so huge, and the public interest in the integrity of counselling, ought to make us be able to exclude them. Why I'm telling you all of this is because you might be able to help, since Rape Crisis are about to spearhead a campaign to legislate to keep therapy notes completely out, unless there is a good reason to think that there is something in there that's relevant, in which case whoever wants it has to go to the court, issue a summons, and have an argument about it with the judge, who, if you look at a model scheme that's been in force in Australia for no less than 25 years, then the judge would only override the victim's confidentiality, very rarely at all. So the law in Australia is very like the law here. The law in New South Wales is the one that led the way. And so if for 25 years the Australians can exclude this stuff unless there's something vital there and let the judge decide, surely we can do the same. Can we, as a Soroptimist movement, support this? Can we make this a key theme in programme action until the victims bill comes in? It's due soon. There is a victims bill on the stocks. It's weak, but this can be amended, and Rape Crisis will drive the campaign to do so. MPs will be persuaded to introduce amendments to block this. Can we consider, as a movement, backing that campaign to keep therapy private? Once you get over the shock that complainants need to choose between privacy and having their case dropped, you can see that you can make the point fairly steadily. And probably we need a new project presently after the observations of special domestic violence courts, which we spent a lot of time on, and I'm going to spend some time on in a minute. But this would be something to try and get a resolution at annual conference about, and do some hard work, run petitions, and so on. Obviously, I can send you this bit of this speech, which shows you, the easy guide to what is actually going on. And we think the Law Commission, who advise about law reform, have this in their sights, and they may propose something similar, but we're not so sure. This is really important, because cast your minds back to Project Soteria and the attempt to tip the police away from investigating the complainant and toward investigating the defendant, and see that this has to go with that. And if we don't remove therapy notes from the forefront of that process. We won't make the shift in police officers' minds that we urgently need to make in order to improve. Avon and Somerset Police, having taken all of this on, have begun to arrest rape complainants at twice the rate that they did only a year ago. They are adapting, and we need to outlaw this last serious invasion of privacy. Can we now turn to the work that Soroptimists have already been doing and speak about the Special Domestic Violence Courts, where you have been doing some observations? A lot of people on the call will have done that. I know that St Albans, who are the hosts, did, and there is a draft now of the, as it were, nationwide, I think it's mostly southern counties, report. But for 5 years now, Soroptimists have been observing how the special domestic abuse courts work so that they can support the primarily women victims and the treatment which the courts are designed to give them, which is maximum support, really. There are now, courtesy of clubs like St Albans, observations that have come from everywhere. Manchester to Milton Keynes, you've got to have some alliteration somewhere, haven't you? Reading to Romford. We've done 22 courts in the most recent report, which is not yet quite final, but is coming on. You may remember I did the first set of observations of the Special Domestic Abuse Court in Northumbria when I was the Police and Crime Commissioner, published in 2018. A small study, a dozen Soroptimists, 2 courts, produced findings of concern, brought change, established a methodology, and the validity of the findings because of the methodology then taken on and improved very, very much, and taken on a broader area in the West Midlands, reporting in 2020, and now clubs across that alliterative national geography have produced the latest report, which we hope can be online and ready by International Women's Day. So we've gone from 223 cases in Northumbria, we've added 300 to 400 cases in the West Midlands, and now 626 more cases have been observed by Soroptimist volunteers. A quick word about the Special Domestic Abuse Courts. Magistrates' Courts first started to have this specialism in Canada and again Australia, bringing specialist focus on areas where traditional criminal justice approaches are less successful, very difficult in ordinary criminal justice approach, where the complainant and the defendant are in an intimate relationship, it's domestic abuse, it's difficult to prosecute, it's hard to be willing to testify. These courts were tested, shaped, and evaluations showed that if they adopted particularly working practices, there could be significant improvement in the outcomes of cases. At the same time, 2 kinds of things were also invented. A MARAC, which loads of you will know about, is where high-risk victims are dealt with by a collection of all the highly relevant authorities, police, local authority, health, and so on, to plan how they should be safeguarded. Nothing to do with going to court, keeping high-risk victims as safe as possible. And to go to the MARACs on behalf of the complainants, the invention of independent domestic violence advisors, still called IDVAs, though of course we call it domestic abuse now to reflect that change to understanding coercive control. And IDVAs are at the root of what we should do next, I think. They were rolled out in 2006, and the working practices that occupy these courts are the 12 components of the Special Domestic Violence Courts. There's been work by CPS, lots of research, but if you have the key components present in the Special Domestic Violence Court system, then they work. You have to identify the right cases and put them there. You have to have trained and dedicated criminal justice staff. You have to have a court listing system that clusters them together on one day or fast tracks them out of the other courts to what are supposed to be specialist magistrates. We need to have separate waiting areas, separate ways in and separate ways out, familiarization visits so people feel a little bit more at home at court, children's services. community-based perpetrator programs, so that men who are found to be perpetrators can be put onto a program that could help change their behavior, but they have to be present and available and collecting data and monitoring to see how they are going, inequality and diversity as well. A specialist criminal court. This is capable, if it works, of being a blueprint for what I'm very keen on, which are specialist rape courts, which I haven't a lot of time to talk about, but they can make the difference to ensure that specialism focuses around these very difficult, traumatized victims who need to have that understanding and need to have that specialism. However, every professional evaluation of the special domestic violence court has shown that there needs to be a presence of independent domestic violence advisors. They are independent of police, CPS, courts, probation. They are from a charity. They focus on the complainant and the complainant's interests and the complainant's safety. They provide a point of contact for the court to the complainant, and they aim to involve the complainant in every decision that might involve them or their children, whether to remand the man in custody, to grant bail, the terms of bail, some awful bail decisions saying the defendant shouldn't come within half a mile of the house, but that traps her in an area of half a mile radius. So you need to have, at times when the victim is not going to be there, because these are preliminary hearings, an IDVA there to say, well, don't do it like that, do it quite differently. And where a domestic abuse complainant has the support of an IDVA, she or he is more likely to attend court, more likely to be confident, more likely to give better evidence. And we have seen the opposite, that if someone who is coming to court facing their partner, a person who's been victimized, who's being controlled, who is afraid, and they're on their own, and they have made themselves in more danger by making a report, which is what happens when people try to escape from coercive control. Of course, the perpetrator's grip tightens, and most domestic abuse killings occur after somebody has tried to escape. So going to court is a very dangerous business. You need to have your independent domestic violence advisor with you. Let's look at all of the observations, all of which make those comments. But in Northumbria, and the 223 cases that my club, Soroptimist club, they looked at, there were only IDVAs present in 3 cases. The much bigger report in the West Midlands, produced in 2020, similarly found IDVAs in this court over here all the time, and in that court over there, never at all. And it called on police and crime commissioners who pay for some of these to review their provision and to ensure that they fill the gaps. The new report still to come out, so I say only this about it, tentatively says that in the 626 cases which were observed nationwide, there were IDVAs present in 158, and therefore absent in almost 500. Possibly a little better, certainly than Northumbria, but by a fine margin. The primary purpose is that IDVA sees the victim through to a new life, refuge if necessary, follow-on housing, safely attending court, checking on all of those decisions in courts as well. In Northumbria, we got IDVAs back in. In the West Midlands, I believe some have improved. We need now, when this national report's being pulled together, then to find out where there were IDVAs and where there aren't. So I know, for instance, that in Portsmouth and Poole, there were no IDVAs. And I know that in Guildford and High Wycombe, there were. But look, for instance, at Derby, where there were not, very close by, where there were none. Why is this happening? What we have to do is look at these individual areas, and we have, as clubs, to go back and campaign. This is as pivotal as the therapy note issue, but in domestic abuse, because it is a key factor. And as surely as we won't turn rape investigations properly onto the men and not the women, if we don't get rid of therapy notes, we will not get effective justice in these special courts when we have vulnerable victims who are there on their own, sometimes sitting 10 yards away from their persecutor with nobody to protect them. And also, of course, when they're not there, as I've said, when complainants don't have to be there on preliminary cases, then IDVAs come into their own, making all these protective measures. I saw one case where there was happily an IDVA there. Obviously, the victim was not. It was a provisional hearing, and there was a child involved. He wanted to see the child. His partner didn't want that man to see that child. He told through his solicitor, the magistrates, that his mother was respected by the complainant, who of course wasn't there, as much as by him, and she would be able to collect the child and bring it to its father happily. The IDVA remembered something she'd heard from the victim, rang her very quickly, and was able to tell the court that he had actually been prosecuted for beating his mother up. So she was not going to be able to guarantee anyone's safety. How important the role of an IDVA is. So there'll be presentations later, I'm sure, about the whole of what this has done. But and in time for International Women's Day, it is a matter of great pride that the Soroptimists have done this. But can we go for considering this year trying to protect therapy notes and demanding better funding for IDVAs? As the data with which I started shows, criminal justice is not working well for women victims of male violence, cost, lack of specialisation, misogyny, all of which is another lecture. But women who are victims are in no position to fight together for change. They're on their own, in need, in distress, at the mercy of the police and the CPS. IDVA charities can ask for money, but of course everybody says, well, they would say that, wouldn't they? It is we women who not only care about our sisters in these issues, but who know what's going on because we have informed ourselves by troubling to do this observation and watch. We, the voices of women who are not victims of rape or domestic abuse, but our identities quite otherwise, doctors, lawyers, psychotherapists, plumbers and electricians, we can say, we play a role in the society. Our voices need to be heard on behalf of the women who can't there. 2 small steps toward justice that we can take, a bit of do it yourself. Over to you now for thinking about it, and over to you right now for questions about all of the things that I haven't remembered to mention. Thank you.
So thank you so much, Vera. I really appreciate your kind of direct approach, and I think we'll just go straight on to Amita really for questions, because I'm sure there are a few questions that are coming through. So thank you so much, and I'll pass over to Amita.
Good evening. So I'm going to start off with the comments. So Sriya from SI Bootlin District has said, it is re-traumatizing the victim, which is a very valid comment. And then we go down to Dorcas, who says, how can women be empowered to continue with their cases instead of dropping the cases? Would you like to address that?
How they can be given the power to carry on. I think I've done a bit of analysis of what drives them to give up.
Yes.
And we do need to reverse the cuts. And obviously that is not all that likely to be happening until, you would expect me to say this, there may be a new government which would have a different approach to this, because we've had some pretty clear announcements about refunding and about improving both the special domestic violence courts, though we've heard less about that, to be honest, but we have heard about rape specialist courts, which I see as very, very important. I mean, the single most important thing that most victims of either of these crimes have ever said to me when I was victims commissioner, and we made it our business to have a massive, as big as we could, network of victims and victims organisation. they have said the key to being able to do this is to have a professional friend beside them. If it's an IDVA because it's domestic abuse, if it's an ISVA because it's sexual violence, whatever the person is called, you need them from the minute you have the courage to report it until the trial is over. You have them there. You need them to help you if you need a new house because you've been raped in your home and a lot of people can't carry on. If you need, to miss work and you have to have someone explain it to your boss, if you need to find a new job, if you're at college and you're going to miss a term, if your children were collected from school by the domestic abuser and now he isn't doing it, all of these troubles, professional advisors, IDVAs and ISVAs are there to support you with it. It's quite ludicrous that we think that people who've been domestically abused or who've been raped can not only go to court, or really, let me put it the other way, can not only cope with all of the things I've just set out, which are frequent follow-ons from this kind of offending, but can go to court as well. They can only do it if they have really, really good support. So kind of going back to my point early on, where only 20% go into the criminal justice system, the other 80% need support and they're not getting it. This is about funding good quality charities, of which there are an abundance, but they don't get enough. I mean, I can't myself think of anything more scientific or more difficult than that. We need these good charities to be properly funded so people can have the support they need to carry on.
Louise, would you like to speak to Dame Vera? Would you like to mention your comment here about the IDVAs and their workload?
Yeah, I was just going to, because I work for our local authority. We in the domestic abuse and violence against women and girls team, and we do have IDVAs that we commission, but I know that their workload is huge, and many of the team are quitting. They're filling new places. I know they're filling a new IDVA, a specialist IDVA for the specialist domestic violence courts here, but I was just wondering whether you think there is something, I don't know if there's something in that the IDVA's caseloads are so huge, they're constantly supporting new, working with new people coming through, that perhaps the court side of it gets left out. I don't know, like maybe that's not seen as priority because things are always moving. It's sort of almost, we need to put more of a priority on it.
It's a really good point. It was the Domestic Abuse Commissioner who kind of pointed out to me that not all IDVAs even are interested in going to court. They see their role in all the other things that I've talked about, and they are not criminal justice specialists, so they don't. In Northumbria, we had that problem. So it started like this. There used to be 6 courts in Northumbria, and they cut it to 2 because of court closures. So there are 6 local authorities. And what used to happen was in each court, so say Newcastle City, if there was a client from Newcastle City there, an IDVA from Newcastle City would go with that client. So a disaster befell when they merged 6 courts into 2, because you could have, with a case list of 50, an IDVA sitting there for 1 case from Newcastle when the other 49 were from Tyneside or Tynemouth or from North. So that really made us confront the issue of how to economically and efficiently organise IDVA presences at court. We did have IDVAs who were willing and qualified to go to court, and that is something that needs to be made plain, that some do need to be ready to do that. So we just had to work out a delegation system, which was, I'm your IDVA and I will look after all your interests. But when you're going to court on Tuesday, it won't be me. It will be my colleague from North Tyneside who knows all about you because we've had a phone call. She'll meet you at the door. She'll make sure you're looked after. And delegating in that way was how we managed to get some IDVA presence back again. So I think, needs must, force a bit of creativity. But I'm now very conscious that some IDVAs don't really want to go to court because they have so much to do elsewhere that it just gets in the way. I think there has to be a system of the kind I've just set out, really. It's a really good question, really.
Thank you. Then Vera, there's a question from Penny, and the question is, has there been any research into police sentencing of DA and sexual assault cases?
Police, when you say police sentencing, do you mean the court sentencing?
Penny, would you like to ask?
Penny.
Yes, police are able.
Hi, Penny. It's fine.
Hello, hi.
Hello. Hi.
Police are able themselves to do some sentencing before it even goes any further if they think that. I mean, I know there have been terms with assault in various cases where they really should not have taken it into their own hands, that they've actually felt that they could actually deal with it. It's probably not called sentencing, but I mean, I know that the police do actually do take it on themselves sometimes to give sentences.
What sort of things have you come across of that kind?
I think assault. I know there was some research done some while ago. I'm not sure, but I haven't been a magistrate now for about 7 years. but I do know that when police were able to start doing some sort of, I don't know if it's called sentencing or whatever, but I mean,
it's going to be an out of court disposal, I suppose.
Yes, it's an out of court.
So what they say is,
yes.
You shouldn't, we can take you to court, we can give you a summons,
Yes.
but if you agree to do, 10 years, 10 days work in the Oxfam shop, or if you agree to do this or to do that, we won't take you to court, you won't get a criminal record.
Yes, it's the out of court disposal.
No, I get that. I don't know that any key research has been done about the level of penalties there. They're very low though, because obviously the courts themselves sentence rather than the police, and so the courts are very jealous of that power. And it's only at very low level when it's a caution or something called a community resolution. And in both cases, the victim is supposed to agree, but you do have to wonder about kind of free will in that situation when the police just don't want to take it on. It probably is a really good thing to do some research about, kind of when we've got time to do it, really, because I think we're probably looking at a bit of more of this report than just the Edwards. We probably need to spruce up the special domestic violence course a little bit. I'm not sure they're as great as they used to be. But thanks for the question. It is a sharp point.
We have a question from Dorcas, who says, how are the Edwards allocated to the victims? Is this done by the police?
No, it shouldn't be. So what I mean, there are two things that can happen. One is the victim goes directly to Women's Aid, Refuge, Solace, whoever the charity are, and asks for help there without going to the police at all, but goes directly for help. They will be given then a helper to help them. And if they're in any kind of medium to high risk, it will be a qualified IDVA. So that's one way that you get a person. Just how the allocation is within the charity, I can't say. Appropriateness, perhaps cultural sympathy, I don't know, but that's one way. The other way is if you complain to the police about it, they have an obligation to report all cases, not just domestic abuse, but every crime. They are supposed to do a drop of data to the victim support hub. In every area, as many of you will know, there is a police and crime commissioner who funds a victims hub to provide victim support for every kind of crime. And the police, when they have a report, are supposed to send all of the details of everybody to those victims hubs. And at that time, if it's a domestic abuse case, it ought to go to a specialist like Women's Aid. And if the person is in need of an IDVA, as opposed to some more general help, then it can be allocated in that way. Again, how person to person it works out, I don't know, but it's very professional.
It's just that during the when we were in Liverpool, we didn't see any IDVA at all during our observations. I was wondering, how are they being allocated? We didn't see anybody following and supporting the victim, and we saw victims, but we didn't see the people coming. So that's why I was wondering How are they allocated? How do they find out? Do they know what to find out? Do they know where to go? He said, thank you.
So that's, I mean, that's what has been found in this research, isn't it, that you've done in places like Leicester. They got no IDVAs in court. Derby next door, or not that far away, they've got every person has an IDVA. That is why we need to campaign. And I think we need to break down this report into local areas. So like Newcastle Club can start a campaign about why isn't there an IDVA in Newcastle when there's one next door in Tynemouth? Why aren't you, Mr. Police and Crime Commissioner, funding what's needed here? But you're quite right. I mean, it's that won't be an issue of allocation. That will probably be an issue that there either aren't enough, there aren't enough to go to court because of what Louise asked about, or I mean, there just aren't any, because it is about funding them. And actually, we need a good deal more than this. We need funding, but we need a whole kind of work structure for IDVAs too, so that all of this kind of exchange where I'll represent your clients because I've got 6 at court myself, so I can take on yours as a 7, all of that can be organized. People can be trained. Those who want to go to court can be trained to do it well. Those who don't can be trained to do everything else. You need a kind of workforce plan for these people as well as sufficient funding. But yeah, I mean, it is very sad. As I said, in Northumbria, there were only 3 IDVAs in the whole of 223 cases that we watched. So sometimes they're just not there.
Thank you. May I call Emma, please, from Northumbria to the screen? You make quite an interesting point about district judges.
Yes, hello.
Hello, you've got a fabulous northeastern accent. I can tell straight away. Hello.
Thank you. Hello. Yeah, so I'm employed actually following the Soroptimist report in Northumbria. And I was employed under yourself, Dame Vera.
Speak up a little bit.
Sorry, I was employed under yourself when you were PCC and then under Kim McGuinness.
Yeah.
And I've recently taken the role back up, and it's through Northumbria Police now. But I've struggled sometimes with the district judges that we do have that sit in our courts, because our DV court is a little bit all over the place at the moment. So we're dealing with domestic abuse cases in the majority of our courts at the moment, whether they be remands or the gap courts or the NGAPs. So the district judges that I deal with, they don't seem to be interested in hearing from me, asking me the victim's point of view on things like bail conditions, special measures or anything like that. And I don't know how to approach them, I suppose, because they just don't seem interested. There's only one district judge that I deal with that listens to anything I've got to say. It's a struggle.
Better not name names, because I might just know them, I suppose. But no, I mean, that's a terrible condemnation. It sounds as if the system of SDVCs is probably breaking down, doesn't it? If they're going to all the different courts and not going on a clustered list to the specialist domestic abuse places where the specialist prosecutor and stuff, that sounds quite a worry. I would myself, if I were you, I would approach the CPS and say, look, I'm the IDVA for this woman whose case is coming on number 6 today, and she has this real problem about his bail terms and she wants it done differently. Will you raise it? If they won't listen to you directly, I would just, ride on the back of another horse if you possibly can. Sometimes CPS are okay. So that would be my advice.
They are excellent in our area, I have to say. They do listen to what I've got to say. It's just sometimes it's not taken on board, but I have raised it with our head legal advisor as well, and with my manager, to see if we can get in with the district judges to do a little bit of training on our role, because there's only 2 of us that cover Northumbria, and it has made a difference. It really has, and I'm so proud to do the job.
Well done.
Thank you.
Thank you.
Thank you very much. Chris Colles, would you like to come forward and make your point about taking action, please?
Hello.
Thank you.
Chris?
Hi, Vera. We're just commenting that the regional analysis will follow the data in the main report. We will have a regional breakdown so that we can all take action following that. That was my point, really, that we will, you know, there will be something that we can all act on.
Yeah, no, that's great. I mean, I think
Yeah.
if you know, each club or a lot of clubs who are interested in this can get their teeth into the local area, you know, we can also do stuff nationally at conference, because now that I mean, you basically have managed it, Chris, so that it's gone from, you know, little Northumbria and even, you know, middle-sized West Midlands to pretty well everywhere. There's now a really powerful lobby that we can, you know, bring to bear, not only locally but also nationally, to try and pressure and, you know, bring pressure on members of parliament and so on to try and improve the position. Because I mean, I don't I haven't had a chance to look at the absolute detail, but I've read the report in the last day or so, and it's not good news, is it?
It is. I think the point you're making about the adverts it's really good. It's good to have some really positive action that we can take following the report. Yeah, we can talk to people about it and try and publicise the results, but to have something else that we can do, I think that's a really good positive step for us to take.
That's what I thought. And also, it's not kind of, you know, whereas the therapy stuff is obviously interfering a bit with the criminal justice process and is more complex, but will be led by rape crisis, has been informed by lots of lawyers, including me. But if we're to take, you know, a campaign on our own, not just backing up the experts, then something that doesn't interfere with the criminal justice process at all, just adds good quality support at court, is the way to take it forward. I would have thought, and it is a repeated deficit, isn't it? You know, we had no adverts, you had some, but not a lot, and here we've got some in areas, you know, doing a very good job, and none in areas. So I think it's a straightforward and sensible and a really good way forward.
Yeah.
Thanks for all you do.
Thank you. Thank you, Kathy Warwick, for putting the link on for Keep Counselling Confidential. It's in the chat. There is an interesting question from Margaret Hyde. Margaret, you may want to come on the screen whilst I read your question. How worried are you about what appears to be a culture of abuse towards women among some police officers and an apparent tolerance within some forces? Tricky.
Yes, I just thought, I know it's slightly off question,
No,
but
it's
on the other
not.
hand.
No, it's not. I mean, it is a very worrying notion that if you are victim of domestic abuse and you call the police, the bloke who knocks on your door was, you know, has abused his wife only the day before. And we've seen the scale of horror, you know, around that guy Carrick and the escalation in the other horrible police officer who's been convicted of killing Sarah Everard, you know, from small stuff to much bigger stuff very, very quickly. Now that and ignoring Carrick, who apparently was known as the Bastard, yeah, that was his nickname. So you ignore that and you ignore what is happening with the other bloke who I'm just reluctant to name these people, really. And you have to say they're surrounded, you know, by a culture that doesn't question their behavior. I mean, nobody is suggesting that other cops knew what Carrick was up to, nor knew that this guy was going to kill, but they clearly, you know, you get to know the people you're working with, don't you? You know, you can tell, you know, what their attitude to women is from the way they do with women you're talking to together. And it's perfectly plain, I'm afraid, you know, that there is in places in the police force a culture that just goes along with this and doesn't question it. And I must say, I've got a bit of admiration for Sir Mark Rowley, who, I mean, he's not new to the Met. Let's pretend he's a new broom. He was there and he was the boss of the unit that had both Carrick and the other one in it. But he seems brave and he seems ready to speak out. He said that there will be police in court, probably 1 or 2 a week for the next year, whilst they get all these people out. and he's determined to change the culture. Now, that is the sort of strongest thing that I've heard such a person in that position say, unlike, for instance, Cressida Dick, which is a great shame because I liked her a lot, but she was talking about bad apples. It's not about bad apples, is it? When the bad apple's been there a long time and he's surrounded by people who, if they don't criticize them, I'm afraid, give them support. So, I mean, I think you have a really good point. How are women to have confidence in police when some of them are themselves rapists and abusers? We've got to rely on all the chief constables to behave like Rowley and try and exclude them and hope that they can recover confidence, because I think it's badly lacking at the moment.
Thank you. One last question, and this comes from SI Southport. Jane Fetcher, would you like to come forward while I read your question? As a magistrate and family court, we see applications for non-molestation orders recommended by the police if they're called out for a domestic incident, sometimes instead of a prosecution. Does this happen in other locations? This means that perpetrators often escape the courts.
Well, they don't escape in the sense that they're going to, if they get a non-molestation order, it's recorded. It should be recorded that they've got it, so that they're on some kind of police list, and if they break it, but I mean, in a way, I am more interested in stopping people from behaving this way than I am in getting them a big sentence. In fact, when people are convicted of domestic abuse, I'd rather they went on a perpetrator change program than that they got sent to prison. But I do see how the police sometimes, if they're not sure whether they will have the complainant going along with them, whether she's got, the wherewithal to give evidence, how long the delay is, I can see why they might go in a different direction and try at least to get some protection. I don't know particularly about non-molestation orders. There's such a lot of orders, aren't there? There's non-molestation, there's DVPOs, seem to change to DAPOs, there's restraining orders. Some of those, I think, have stronger backup. What you want really is, if you're going to try and do a protective and preventative order, is to have one that if he breaches it, it's a criminal offence. So you've just given him one chance, but he's already on record, and if he breaks it, he's going to be prosecuted. So I'd be surprised if it doesn't happen in a lot of other ways. And I think it needs to be, handled with care, really.
I think the point of my question, Dame Vera, was that we end up with literally on a one day, probably 6 or 7 women come forward who have been victims to a greater or lesser extent of domestic abuse in their homes around their children. And when the police are called out, their answer is, well, we won't prosecute him, even though he's beaten you up, but go to the family court and put him for an ex parte, without him knowing, go to the court and get one of these orders. It protects them for a little bit of time, and it's the idea, I think, is almost a temporary measure, because then rarely for longer than a year, sometimes only 6 months, and it gives the perpetrator a chance to sort of regroup and abuse again. There's no program for him, but as you say, if he breaches the non-molestation order, it's a criminal offence. The non-molestation order doesn't show on his record if he doesn't breach it. If he does breach it, it becomes a criminal offence. So it almost gives a bit of breathing space, but doesn't really treat the problem, because he can go back in.
And so, I mean, 2 things there. One, do the police say why they are taking this route and not a different one? And then, whilst you're reflecting on that, when we passed the Domestic Violence Crime and Victims Act in 2004, just so happens I was on the Bill Committee. So I was a member of Parliament at that stage, a backbencher, not a minister. And we had the difficulty that I was all for, really, putting orders into the hands of the police, because then, they would have a record of it and they would back it up. But women campaigners were not happy at the idea that women victims didn't have self-determination, and they wanted to retain the right to go to the family court and ask for a non-molestation order if that's what they chose to do. So we left that loophole, I'm afraid, open on a very well-meaning basis. But now again, you just have to worry about free will, don't you? And the police are just saying to her, we're not going to do anything, so you should back it up in this way. But do the police say why they're taking this, why they've taken this route? You presumably don't even see the police, do you? You just see her.
No, we just get the orders come into court.
Yeah, no, I mean, it seems to me that if there is an IDVA involved, or if an IDVA could be got involved, do you ever see IDVAs in the county court?
I've seen one or two when the situation's been really, because obviously we're thinking about the children. So if there are children involved, they quite often see an IDVA who has been working with, with a victim. I think it goes back to what you said before, actually, about the police are so, the number of police has dropped, and they just want a way of handling it without having to do too much work.
They need to do a risk assessment, don't they, to understand the right way to go to give her optimum protection.
Yeah, sure. But that was a really interesting point about the zonal, about the 50 meters. I'll remember that one. 50 meters.
Yeah, don't trap her within 50 meters, because maybe she can't take the child to school then, or yeah, what, he can be anywhere, as long as he's not in those 50 meters, and she can't, she goes outside the 50 meters, then he might be there waiting for her. Because we all used to have notions about tagging perpetrators. We piloted some gear in Northumbria. I remember, I don't know, Emma, if you were around then, but you had a phone and you had a tag, and the guy had a tag and a phone, and she had a phone. And if the tag came near her phone, within whatever the fixed distance was, the phone rang, and it rang in the police station as well. And she knew that he was near, so she could go away. And the police knew he was here, so they went and arrested him because he was in breach of bail. And stuff like that is quite handy, but it doesn't seem to me that there's a great deal of that now. And I'm guessing that again is cut, because technology like this is slightly experimental and costs quite a lot. So pilot, and I just don't know what's happening in those areas where it could be useful. Could back up, for instance, a non-mol, couldn't it? If you could order that he's tagged, then if he goes near her, the alarm bell will ring and she can do something about it. I don't know whether that kind of stuff is going on these days.
Thank you very much. I've been nudged several times now. We're well over time. Please, can I pass over now to Barbara to give us the vote of thanks. Thank you.
Thank you.
Dame Vera, it's a great pleasure for me to be able to thank you, not just for giving up your time, but for the call to arms that you've laid before us, and your call to do what we can in the interests of women's justice. We've, I'm sure, all heard your plea for us to take action, both locally and nationally, to keep counselling confidential, and indeed to campaign for better funding for IDFAs. You started this evening by saying that the picture for women's justice was depressing and shocking, and that the criminal justice system is not working well for women victims. And I think our experience of doing the court observations really shows that very well. There's a risk, I think, and it's been alluded to a bit in the questioning. Violence court report comes out, we could get bogged down in the detail of all those things that are wrong with criminal justice around the UK. But you've given us very, very clear guidance on how we can avoid that by focusing on those two specific areas, keeping counselling confidential and campaigning for better funding for IDFAs. I'm sure we can all do more locally as well, but I think if we take those two messages away tonight, we will all benefit, and so will the victims. And I'm sure that's what you and we all want. Thank you very much indeed for spending time with us this evening and for sharing your views so openly. Before we show our collective appreciation for Dame Vera Baird, we will be taking some screenshots now. So anyone who unmute yourselves and show your appreciation in the usual way.
Thank you very much indeed. It's been a great meeting. Thanks a lot.
Thank you, Vera.
Thank you. Thank you very
just
much.
before you disappear, the theme for International Women's Day is embracing equity. So can we now have everyone giving themselves an embrace for the cameras?
Yes.
Denise, have you captured that?
Yes. Oh, she's got Judith with her.
Okay. Thank you very much.
Thank you very much, everybody.
Okay.
Bye.
Thank you to everyone who's attended.
Thank you very much.
Attended tonight.
Thank
you,
you.
Vera, again. I hope you've all enjoyed the evening. And we will finish with a small amount of club business. So anyone who would like to leave now, please do so.
What's wrong with that too, Anna? To leave, is it? Or leave him. Oh yeah. Yeah, that's leave meeting.
Okay. It looks as if most of those who are not members of the club have now gone. So really,